Good morning all. So last 2 days we discussed about day 1. Today we will be discussing about day 2. The content which I gave you in the PDF, more topics I took in the classroom. I will be discussing the same as well. So we know that Article 21 of the Constitution, which is protection of life and liberty, is getting extended. It is one of the PYQ also. Which of the following comes under the Article 21 of the Constitution? We all know that recently the women health care and the sanitary thing is also comes under Article 21 of the Constitution. Right to marriage is also coming under the Constitution, Article 21. Sanitary protection, safety is also coming under Article 21. And sexual orientation, right to have a sexual orientation is also part of Article 21 of the Constitution. But exam point of view, what you have to remember, there are some specific judgments we can expect in match the following point of view. Why? Because you know that Article 21 is ever evolving concept. Right to drinking water, right to clean environment, right to wildlife, right to free air, right to pure drinking water, this all comes under Article 21 of the Constitution. But there are some provisions under Article 21 of the Constitution which are mainly given through few judgments. What are those? First one, right to privacy. Right to privacy comes under which judgment? Right to privacy. So before that, bail also, recently, why I am discussing about it. Right to bail and anticipatory bail is also one of the Article 21 of the Constitution, right to bail and right to anticipatory bail. You know that what is bail? A person, when FIR is being filed and went to the court, then there will be judicial custody. When a criminal is in the police, it is called as police custody. When the criminal goes to the court before the magistrate, and the magistrate when sends to the custody, it is called a judicial custody. That means when we are in the prison, it is called as judicial custody. Means whatever happens to us in the custody, who is responsible? Magistrate is responsible. In the police custody, who is responsible? Police is the responsible. That is the reason we have what? Some police encounters, police deaths will be happening. Police will be seen as responsible. In prison, if any deaths happen, the judiciary will take the responsibility. The prisoners, the jailers will be arrested. So what happened generally? Bail, they will be getting denied. They will not get bail soon. So the Supreme Court of India in 2015 told that bail, anticipatory bail means before arrest when we get a bail, so that we won't be arrested, it is called as anticipatory bail. Like in SC/ST Prevention of Atrocities Act, there is no anticipatory bail. In POCSO, there is no anticipatory bail. In section 498A, where wife file a case on husband, then there is an anticipatory bail. So anticipatory bail or bail is also Article 21 of the Constitution. Bail, so it's a right. So we can go to the court and we can ask bail. If the court is denying bail, we have the right to ask the reasons why you are denying the bail, why you are denying me anticipatory bail. So before 2025, right to bail and anticipatory bail was not under Article 21, but from 2025 onwards, right to bail and right to anticipatory bail is also Article 21 of the Constitution. Right to menstrual hygiene, I told you, right to menstrual hygiene. Right to marry is also very recently was been highlighted as Article 21 of the Constitution. But there are 5 major judgments. First one, right to privacy. Right to privacy comes under which judgment? Puttaswamy case. In Puttaswamy case, right to privacy is also a fundamental right. For example, if a child, how is your, thank you Chaitanya. Only one person asked me how is your health, so I should reciprocate. Thank you for understanding, Chaitanya. Right to privacy, case Puttaswamy versus Union of India. Privacy is also a fundamental right. Right to clean environment. Right to clean environment, in this only, right to pure drinking water, right to clean air are coming under which judgment? Subhash Kumar versus State of Bihar. We can expect match the following. Subhash Kumar versus State of Bihar. Right to speedy trial. Right to speedy trial. Husainera Kathon versus State of Bihar. These are, sir, why these judgments also we have to remember, no? We are not discussing about this judgment. These are famous judgments which are interpreted in multiple dimensions. For example, right to privacy means not only private life, it's sexual orientation, my own choice, lot of things will come under it. So, right to privacy, Puttaswamy, right to clean environment, Subhash Kumar, right to speedy trial under Hussain Khatoon versus State of Bihar, right to speedy trial, right to livelihood, this is also very, very important, right to livelihood, Olga Tellis versus Mumbai Municipal Corporation, under this only street vendors, their livelihood came under existence, street vendor, that is right to livelihood, Olga Tellis versus Mumbai Municipal Corporation, right to die with dignity, yesterday one case came, yesterday, euthanasia. There are two types of things are there. Euthanasia, one is called as passive euthanasia, other is called as active euthanasia. Passive euthanasia means what? Mercy killing. Euthanasia means what? Mercy killing. The two types of mercy killings are there. One is called as active euthanasia, other is called as passive euthanasia. Active euthanasia means when I give sterile, when I die by giving a, when I kill doctor, when a doctor kills by giving deadly medicine, it is called as active euthanasia. If I remove the support, if I remove the health support, it is called as passive euthanasia. So, right to die with dignity is being under which judgment? Common Cause versus Union of India. This case came for the first time Aruna Schonberg. There was a woman called as Aruna Schonberg. Aruna Schonberg was a nurse in Mumbai, one of the hospital. So, she was been raped by one of the ward member. So, she went into vegetative state for 30 years. So, after 30 years when she became 60 years old, the NGO filed a suit in Supreme Court that people are serving her, they are ready to serve her, government, that hospital people are serving her, but they are ready to serve more 10 years, but there is no chance of serving her. So, we want her to have euthanasia. We want to give her passive euthanasia. So, up to now passive euthanasia was there till recently, 2 days back. Passive euthanasia was there. Now, Supreme Court is looking into active euthanasia also. Supreme Court is looking into active euthanasia. Two things you have to understand. Up to now, what is valid? Passive euthanasia. It's a right. Passive euthanasia means if I am having ventilator, they will remove the ventilator. Active euthanasia means they will give a medicine which is deadly. That is called as active euthanasia. What is legal in India? Passive euthanasia is legal as of today. As of today, what is legal? Passive euthanasia is legal. Now, recent case, Supreme Court is also looking into active euthanasia. Now, they didn't came with any conclusion, but they are looking into active euthanasia. These are the famous judgments with respect to, yes, Article 14 and Article 326. Voters' right West Bengal. What happened? Didi Mamata Banerjee went to Supreme Court against Sir. What is Sir? What is Sir? Special Intensive Revision. Special Intensive Revision of Electoral Rolls. It is nothing. Election Commission of India came up with an innovative idea called as Special Intensive Revision of Electoral Rolls. It means that complete electoral rolls will be checked, will be audited. Complete electoral rolls will be checked, complete electoral rolls will be audited, such that if any ghost electoral voters are there, ghost means who died but still his vote is present, ghost, or who is not part of this particular constituency, his vote is there, or wrong voters are there. These all wrong voters, ghost voters, false voters will be removed by this special intensive revision of electoral rolls of West Bengal. So, the Mamata Banerjee went to Supreme Court questioning that we don't want any Sir, we want old electoral roll only. Why? Because within 3 months elections are there in West Bengal. We don't want special intensive revision electoral roll. We want the same electoral roll. Hence, it is in the news. Mamata Banerjee moves Supreme Court against special intensive revision, seeks West Bengal elections on existing voter rolls. So, on what basis? On what basis Election Commission of India is going for special intensive revision? Two articles, Article 14 and Article 326. Article 14, right to equality, means whoever is present in the constituency, only that particular person should have voter card, other people should not have voter card. If other people are having voter card, it is violation of right to equality. Article 14, Article 326. Election Commission of India is getting the power to design the electoral roll and Election Commission of India is having supreme power with respect to management of voter list. So, under Article 14 and Article 326 of the Constitution, Election Commission of India is having the power to go for what? Sir. To go for what? Sir. So, Sir of Election Commission of India is constitutionally valid. Why? Because it comes under two articles of the Constitution, Article 14 which is called as right to equality, Article 326 which means that Election Commission of India is having the power superintendence of electoral rolls and voter list. Under this, Election Commission of India is having this. Yes. What? Remove duplicate or ineligible voters, include new eligible voters, ensure accuracy in voter list. Errors in revision may lead to wrongful exclusion of legitimate, that is a problem. This is what? Special intensive. Removal, include, ensure accuracy of voter list. If who are not there, they can be added. So, a proper audited electoral roll can be added after special intensive revision. So, hence Supreme Court also accepted it, Election Commission of India is also going with it, but West Bengal government is against it. Why? Because it is saying that we want to go with existing voter roll. Protection of voting rights, fair and transparent electoral rolls, ensuring equal treatment of voters and safeguarding universal adult suffrage. These are the issues which were been questioned by Mamata Banerjee. See, 2017 question. Right to vote and to be elected in India is what? You know, this is the fact which I accept honestly. In 2000, every year after the prelims examination, next 8-9 hours we will be very much active in the making of key and explaining the key. So, 2017 also I remember, right to vote and to be elected in India, it is I kept in our key constitutional right. Big academies, they gave it as legal right. So, everyone questioned it is not constitutional right, it is legal right, legal right, legal right. But you should get this point. If it is present in Article 12 to 35, if anything is present in Article 12 to 35, it is called as fundamental right. If anything, if it is present by a law, if anything it is included by a law, it is called as legal right. Anything which is not part of fundamental right, but it is included in the Constitution, it is called as constitutional right. Article 324, Article 326, electoral rolls are present. The word called as electoral rolls are present, hence it is a constitutional right given to the individual. It is a constitutional right which is given to the individual. So, sometimes we have to be very careful. This question was nowhere, after 2017 only everyone started discussing about it. Before that 2017 this type of question was not there. Then how to answer such questions, sir? You have to use your IQ, you have to use your intelligent guess. Like what? It is not there in fundamental right. It is not there in fundamental right. There is no law also. There is no law. Why? Because we didn't came across any law. It is not. It can be a natural right, it can be a constitutional right. Natural right. Natural right means any citizen who is minor also will have the natural right. Then minor is not allowed to vote. So, natural right is also not allowed. Then constitution is left. Then why we should think about constitution? Yes, it is present in the constitution under Article 326 and 324. So, it might be a constitutional right. So, see, when you are answering the question, first you should look it precisely. When you don't know precisely, then you have to look around and you have to come to a conclusion. The answer which is 90% true is a correct answer. Answers will not be 100% correct. Very near to the answer is also correct answer. Delimitation Commission, this current affair which is there in the news, Delimitation Commission. So, if you know, 2027 is a very big year. 2027 is a very big year, mainly because it is going to give new hopes. It is going to create new political leaders. It is going to change the equations of Indian political system. It is going to alter the boundaries of constituencies, MLAs and MPs. The number of MLAs and MPs are going to increase. So, the complete architecture of our Indian political system is going to change. That much big thing is Delimitation Commission. Delimitation Commission happened in 2001. Recently when it happened means after 2001 census, 2002 delimitation commission happened and the number of constituencies were being increased, or that was the fourth time when the delimitation commission was been constituted. Now again 2027, not 2026, 2027 the delimitation commission is going to be constituted after 2026 census. After 2026 census, 2027 delimitation commission is going to be constituted. So expected question for 2026 prelims, expected question for 2027, UPSC should ask question. This is original civil service. UPSC should ask you about delimitation commission and you should know about delimitation commission. So what is delimitation commission, sir? Delimitation commission is reorganizing, rearranging the boundaries of the constituencies of Lok Sabha and legislative assemblies is called as delimitation commission. So it is present in the constitution under article 82. Under article 82 it is present that for every, it is constitute after every census. After every census there will be a delimitation commission. According to the delimitation commission, the reorganizing of the MLA seats and MP seats will be happening is present in article 82. Then article 170 similarly for legislative assemblies. So it is present in the constitution. It's a constitutional obligation after every census. It's a constitutional obligation after every census there should be a delimitation commission and the delimitation commission will reorganize, rearrange MP constituencies and MLA constituencies. Present for Lok Sabha for 82 article, present for legislative assemblies for 170 article. And what the delimitation will do? The delimitation will rearrange the boundaries and will tell that for this many states, for example, in Telangana we have how many MPs are there? 17 MPs are there. In Andhra Pradesh how many MPs are there? 25 MPs are there as of now. So the 25 MPs will be changed. Now the things are going like this. And MLAs are 175 in Andhra Pradesh, MLAs are 119 in Telangana. So the legal jurists are telling that Telangana is going to have 154 MLA seats now. Means next election 2029, Telangana is going to have not 119 but 154, means nearly 35 extra. And Andhra Pradesh is going to have from 175 to 220, means how many? 45 MLA seats are going to increase. And both together Andhra Pradesh and Telangana is having 42 MPs, the 42 MPs are going to increase by 55. How many MPs are increasing? 13 for both together. So those many changes are happening. Now comes the question. So whether any delimitation commission rearrangement of MLAs and MPs, whether we can sue in higher court? No. It is binding and final. It is binding and final. The delimitation commission decision with respect to MPs and MLAs reorganizing of constituencies is final and binding. We cannot call for higher court. We cannot call for higher court. That is one thing which you have to remember. Who will be constituted? The delimitation commission. The delimitation commission will be constituted or appointed by the President of India in collaboration with Election Commission of India. So delimitation commission will have 3 members. Number 1, retired Supreme Court judge, who is called as chairperson. Retired Supreme Court judge. Second, Chief Election Commissioner will be the second member. Chief Election Commissioner will be the second member. Third, respective state election commissioners. If they come to Andhra Pradesh State Election Commissioner will become the member. So that 3 members will be there in the delimitation commission. First, who is the chairperson? Retired, not CGA, retired Supreme Court judge. Second member is who? CEC, Chief Election Commissioner. Third member is who? That state election commissioner. These 3 members will be working in the process of delimitation, and what decision they take, it is binding and final. We cannot call upon in higher courts. So there is no concept of judicial review for delimitation. There is no concept of judicial review for delimitation. Who appoint the delimitation commission? President. Who are the members of the delimitation commission? Retired Supreme Court judge will be the chairperson, CEC will be the other person, respective state election commissioner will be the other person. So the 2 members are permanent and state election commissioner will be changing for every state. So listen carefully. I divided like this, understand this. Up to now, we have delimitation 1951, 1961, 1971, and again we have 2002 or 1973 we can tell on the census of 1971. So, first delimitation commission, remember this, facts. First delimitation commission chairman was Chandrasekhar Iyer. How many Lok Sabha seats were been there? 494. Which year? 1951. And the report was out in which year? 1953. 1953 based upon which census? 1951. So, first delimitation commission was been constituted in which year? 1953. Based on which census? 1951. Today how many MP seats are there in Lok Sabha? 545. At the time of independence how many are there? 494. So, today and at that time it is not the same number. Second delimitation commission happened in 1963. Based upon the census how many? 1961. 1963 based upon census 1961. How many MP seats are there? 522. How many MP seats are there? 522. And this is the delimitation, second delimitation commission. First we have to remember, they will ask first recent, no? So, first I kept. Who is first? Chandrasekhar Iyer. How many are there? 494. Which year? 1953. Based on which census? 1951. Second which year? 1963. Based upon which census? 1961. How many are there? 494 to 522. Then we have third commission. Which year? 1973. So, first 10 years we have 51, 61, 71. Based upon which one? 71. Justice J.L. Kapoor. If you want to remember, you can remember, if not, you don't want. How many increase the seats of Lok Sabha from 522 to 543? 543. 42nd Amendment Act froze any further delimitation of constituencies for election to Lok Sabha and state legislature until 2001. That is the reason 1981 we don't have, 1991 we don't have, again we have in 2001. In which year? 2002. So, for 30 years after 1971, 81, 91, 2001, 3 years, 3 decades, 30 decades we don't have. Why? Because 42nd Constitutional Amendment had put froze on no more delimitation commission. So, 1971 census and 1973 delimitation commission, how many members? 543. What are the remaining two? Anglo-Indians, it's fixed, Anglo-Indians is fixed. So, overall 545, 2 are Anglo-Indians who will be nominated by the parliament, 2 will be Anglo-Indian community, 545 overall. Which constitutional amendment had frozen? There will be no further delimitation commission after 1971 census, 42nd Constitutional Amendment Act. The next delimitation commission will be in which year? To after 2001 census. So, again we have in 2002 based upon which census? 2001 census. Based upon which census? 2001 census. There were no delimitation exercise after 1981 and 1991 census. Fourth delimitation commission was based on 2001 census headed by Justice Kuldeep Singh. What is the recent delimitation commission? 2002. What is the recent delimitation commission? 2002. Number is how much? Fourth. Based upon which census? 2001. Constituted in which year? 2002. Who is the head of it? Kuldeep Singh. They told that we are not going to increase the number of MP seats. We are going to continue the same number of MP seats which has been fixed under 1971. So, same how many we are continuing now? 543. Again, 84th Amendment Act 2002 froze any increase in seats till 2026. Again, 84th Constitutional Amendment Act 42 into 2. How much? 84th. Again 84th what they told? No more further till 2026. Means 2001, 2026. How many years? 25 years. After 25 years only again there will be census. Based upon that census we will have delimitation. So, next year we are going to have delimitation. The delimitation is going to be which number? Fifth number, and that delimitation will be after census. Why? Because 84th Constitutional Amendment Act very clearly told that after 2026 whatever the census come, after that census only the delimitation commission should be constituted and the reorganization of MP seats and MLA seats should happen. So up to now how many delimitations we have? 4. 1953 based upon 1951, 1963 based upon 1961, 1973 based upon 1971. Then we have 42nd Constitutional Amendment Act, no more till 2001. Then we have 4th in 2002 based upon 2001 census. The numbers of 3rd and 4th are same. Again we have 84th Constitutional Amendment Act and we froze it till 2026. Now we are going to have which constitution? Now we are going to have which delimitation commission? 5th delimitation commission. That too after which census? 2026 census. So census. Now census. Now census. Why? Because we are going to have delimitation only after census. Started now, but will be released in 2027. Hence, we will call it as census 2027 only. Delimitation commission has been not constituted yet. Delimitation commission will be constituted only after completion of census. Prelims point of view very important. Ministry of Home Affairs Office of Registrar General and Census Commissioner is in charge of conducting the census every 10 years. You will have UPSC Bangla, Dolpur House. You will go to UPSC interview, no? Which is called as Dolpur House. Shah Jahan Road. That road is called Shah Jahan Road. Your UPSC building, opposite is this building. You can see it. Census Commissioners and Registrar General Office is just opposite to UPSC building. This will be conducting what? Census. The census will be conducted by which body? Registrar General and Census Commissioner. Working under which ministry? Ministry of Home Affairs. So Ministry of Home Affairs, there is a body called as Registrar General and Census Commissioner who will be enumerating the population, who will be calculating the population, which the document is called as what? Census document, for every 10 years. After independence, census organization was formed ad hoc for each census. Then we have a Census Act of 1948, legislative. It is having legal backing. Which act? Census Act of 1948. It is having a legal backing. According to Article 246 of the Constitution, so where the census is present? The census is present in Article 246 of the Constitution. Under Article 246 of the Constitution, we have Union List. Under Union List, we have what? In the 7th schedule, Union List, we have what? Census. So hence the census will be conducted by whom? Central government. Why census will be conducted by central government? Because census is present in Union List in 7th schedule, which is redirected there by Article 246. So Constitution gave the power to conduct census only to the central government. So state government cannot calculate the numbers. If state government goes and calculate the numbers, it is violation of Constitution. Why? Because in the 7th schedule of the Constitution, under Union List, census is present, and who is having the power to enumerate the population? Only the central government. And Article 246 also directs to the 7th schedule of the Constitution, which is called as Union List, and in Union List what is present? Census is present. And who is the power of authority for census? Ministry of Home Affairs, Registrar General and Census of India. For the first time after independence 1951, ad hoc office was been formed. Then after we have a permanent office called as Registrar General and Census Commissioner. 2011, when we started? We started 1872 onwards. We started from 1872 onwards, but regularly we started doing from 1881. We started from 1872. Before that, which dynasty or before British, who conducted census? Mauryan dynasty. It is the only kingdom in the Bharatavarsha who conducted census, that is Mauryan dynasty. After Mauryan dynasty, 1872, British government started conducting census, but it was not full-fledged census. They started, but full-fledged census started from 1881. 1881, 1891, 2001, 2011. Now we don't have 2026. So which one now? 15th. 1872 we started, but we didn't complete it. When we had a complete census, 1881. When the British India took the initiative, 1872, but they didn't compile it. When the compilation of numbers happened, 1881. So 1881 will be considered as what? First. So now 2026 census is which number? 15th number. And this census is first digital census and will include a self-enumeration option. For example, what? Earlier what? They used to come and knock the door. How many are there in your home? They used to write and they go. Now people are migrated, people are staying elsewhere, people are doing jobs everywhere. So now digital means what? They are taking your thumb impression, biometrics. If you think that my biometric is not there, we can go to census, online, we can give our biometric and we can add ourselves. That is called as self-enumeration. The concept of self-enumeration first time in 2026, the concept of digital census for the first time in census 2026. So census 2026 is how much number? 15th number. It will be conducted in two phases. First phase we will count only houses. How many houses are there? Then second phase, with houses they will come. For a very house, for the house they will put some sticker and they will go. Census people. So with that sticker they will come. So this sticker, number one. Then they will ask how many people are there. So number of houses, number of people. Number of houses, number of people. Hence two phases. First phase is number of houses. Second phase is number of people. Very important. Reference dates means by which date they have to calculate the numbers. For Ladakh, for Jammu and Kashmir, for Himachal Pradesh, for Uttarakhand. Northern hilly region, it is October 1st, 2026. Rest of India, March 1st, 2027. March 1st, 2027. So the complete calculation will be completed by March 1st, 2027. They compile in the month of April, and by May 2027, census document will be given, and immediately in the month of June, delimitation will be constituted. By October or November, the delimitation commission will be done. This census will include what? Caste enumeration, marking the first official collection of caste data since the 1931 census. Sir, in 2011 also no caste, socio-economic caste census happened. The data was not released. Socio-economic caste census happened in 2011. SCCC, socio-economic caste census, but the caste census data was been not released. Now we are doing caste census and we are going to reveal also. That is the reason we call it as what? First official transparent caste census. The 2011 socio-economic caste census, the caste census is only with the government. It was for government, now it is for people. Census 2027. Then more about citizenship topic is there. You have to understand this. There are some concepts like NPR, NRC, census. What are these, sir? Census, understand the differences. Census means only calculation. If I am calculating this class, it is called as what? Census. Census, if I am calculating this classroom, that number is called as census. When I am enumerating 1, 2, 3, 4, 5, 6, 7, 10, 15, 50, it is called as census under Registrar General and Census Commissioner. For what purpose? For policy making purpose. For what purpose? To understand the demography of India, so that the government can make a policy. Second, NPR, National Population Register. What is this? National Population Register. How many residents are there who are staying since last 6 months? I'm not bothered whether they are migrants or immigrants, whether they are legal, whether they are illegal. I will go to every home. How many residents are there? How many residents are there? How many residents are there? Only one question, whether they are staying since last 6 months. Yes, then they are residents. When I am calculating number of residents, it is called as what? NPR. NRC, National Register of Citizens. Identification of citizens. Now I will identify the citizen, whether that citizen is Indian citizen or foreign citizen, Indian citizen or foreign citizen. NRC happened up to now only in Assam. After 1971, Indo-Bangla War, when the Bangladeshis wiped into the India, so complete demography of Bangladesh, complete demography of Assam has been changed. Then we have NRC to calculate who are legal citizens, who are illegal citizens. So up to now NRC happened only in Assam. 3, understand, census to calculate the numbers, and that numbers will be helpful in policy making. National Population Register, I want to know the residents, either Indians or foreigners. How many are leaving? Is called as National Population Register. National Register for citizens. Who are our citizens? Who are foreign citizens? Who are our citizens? Who are foreign citizens? That is called as what? National Register for Citizens. Hence, we have 3 types of calculations. One is called as census calculation, other is called as NPR calculation, other is called as NRC calculation. Now you see NPR. What I told, same. To create a comprehensive identity database for all usual residents, including both citizens and foreign citizens. ఎవరెవరు ఉన్నారు, 6 నెలల నుంచి ఎవరెవరు ఉంటున్నారు అంతే. A usual resident is someone who has resided in the place for 6 months or more. Mandatory for all residents to know the residents. That is called as NPR, NRC. To identify legal citizens of India, aiming to detect illegal immigrants, only Indian citizens, only implemented in Assam so far. That is called as NRC. This difference you have to know. Census is calculating. In that census calculation, we will calculate who are Indian citizens, who are non-Indian citizens. We will keep the only Indian citizens we will calculate. NPR, both. So you tell me, NPR number will be more or census number will be more? NPR number will be more. NPR number will be more. Census number will be more or NRC number will be more? Census number will be more. In NRC, we will find only illegal immigrants. NRC main target is finding illegal migrants. NPR, database of residents, it does not offer the right to claim citizenship, just residents. Is privacy guaranteed under? Privacy is not offered formally. The data covered in NPR is available for government use. The Home Ministry says no, but a 2018 government report says NPR is the first step towards the creation of NRC. How NPR different from census? Census is a primary source of socio-economic and demographic data which is shared as aggregate. How will government use NPR? You will use for identifying beneficiaries for welfare programs like in the case of Ujjwala. What I told, same. NPR, NRC, census. Any doubts? NRC only in Assam to identify illegal immigrants. NPR to identify all the residents. It can be Indian, it can be foreigners. Census Commissioner only the citizens who are living in India. For that purpose, we are having two phases. First phase, houses, in that house who are living. Number of houses in that house who are living. So that we will have number for every house. Oh, he owes this money, this house this money. So how they will calculate? In a village, 100 houses are there. So in 100 houses, 5 people are there. So 500 will be the population. Then again, Lokpal was in news. Shivani, sir, a census in union list, but we see some states go for state caste census independently. Is it allowed according to commission? No, no. See, I told you, census I didn't told caste census. The census, overall calculation can be done only by the central government. Caste census was being done by Karnataka. Caste census was also done by Telangana state. Caste census is different and census is different. Officially, who will be having the power to do the enumeration means it is only central government. Got it, Shivani? Caste census we can do state-wise, but census they cannot. There are some statutory bodies. Lokpal in the news, Anna Hazare, 2013, UPA government, Ram Leela Maidan, Arvind Kejriwal, Anna Hazare, these people had a huge agitation. They asked for an ombudsman. We want an ombudsman, one corruption agency which should be responsible for all the corruptions which are happening across India, which should also question the Prime Minister of India. A very big movement happened and the central government had bent its neck and accepted for Lokpal and Lokayukta. Hence, a legislation was being passed in 2013 named as Lokpal and Lokayukta. But the bad luck is, Lokpal Lokayukta, when it was being formed, till now, no Lokpal was been appointed. No Lokpal was been appointed. Act was been made, but no Lokpal was been appointed. So hence it is in the news. So we are not bothered about who is appointed or who is not appointed. Lokpal, what is the composition, what are the powers of the Lokpal, and it was been legislated by which act? Lokpal and Lokayukta Act of 2013. See, discussions on strengthening anti-corruption mechanism and appointments to the Lokpal of India have kept the institution in focus. Appointments. Lokpal periodically reports on corruption complaints against public servants, including high public officials. So, the Lokpal appointments are not happening. If Lokpal is not there, then whom we should give the complaint? There is no Lokpal appointment only. We don't have Lokayukta also in states. Karnataka have Lokayukta. Without Lokpal, if CBI is there, CBI head should be there. No? CVC is there, CVC head should be there. Then only I can go and contact him. Lokpal was there, but there was no Lokpal chairperson only. So hence appointments of Lokpal is under question. Hence you should know about the body of Lokpal. Why it was in the news? 2025, a brief discussion was happened for the appointment of Lokpal. But suddenly they stopped. So Lokpal will be appointed, Lokpal will be appointed, Lokpal will be appointed. Hence it is in the news. Lokpal and Lokayukta Act. Which year? 2013. Which is having what backing? Statutory backing. Which is a legal body, which is a statutory body. Independent Anti-Corruption Ombudsman. Lokpal consists of. Lokpal means what? Remember this. How many members? 8 members. 50% members must be judicial members. 50 members must be from SC, ST, OBC, minorities, women, and the chairperson. So how many members should be there? 8 members should be there. And in that 8 members, 4 members should be judicial members. Another 4 members should be from SC, ST, OBC, minority and women. In that, one will become the chairperson. 4 members will be judicial members, 4 members will be SC, ST, OBC, women and minority. 4 plus 4, 8 members. In that, one person will become the chairperson. So Lokpal constitutes how many members? 8 members. Up to 8 members. Chairperson plus, yes. Chairperson plus 8. Yes. Chairperson plus 8. Overall 9 members. Overall 9 members. Chairperson plus 8. In these 8 members, 4 members will be judicial members, 4 members will be from SC, ST, OBC, women and minority. C plus 8. C plus 8. What are his powers? Appointed by President on recommendation of selection committee. There will be a selection committee. These Lokpal members will be appointed by what? Selection committee. What is a selection committee? Prime Minister, Speaker, Leader of Opposition in Lok Sabha, CJ or his nominee, plus eminent jurist. Remember this. How the Lokpal will be constituted? The Lokpal will be constituted by a body of 5 members. Prime Minister, Speaker of Lok Sabha, Leader of Opposition or CGI or nominee who is appointed by CGI and eminent jurist. These 5 members is called as what? Selection committee. The selection committee will be appointing whom? Lokpal. So opposition is there, speaker is there, judicial member is there, jurist is there. So hence the Lokpal body will be neutral independent body. 5 members body will be appointing chairman plus 8. What are the power? Jurisdiction. Jurisdiction. Prime Minister is also under the ambit of Lokpal with certain safeguards. In prelims, he will not give certain safeguards. Prime Minister means Prime Minister you can give. Prime Minister. In mains, you have write Prime Minister in brackets with certain safeguards. Prime Minister is also under the ambit of Lokpal. If Prime Minister is there, then all Union Ministers will be there. Then all MPs, Prime Minister Prime Minister is there, Union Minister is there, MPs are there, Group A, B, C, D, central government employees are there, officials of body receiving government funds. These are. So, what is the jurisdiction of Lokpal? We can expect a question. What is the jurisdiction? Prime Minister, Union Ministers, MPs, Lok Sabha and Rajya Sabha. Fourth, Group A, B, C, D employees, plus who are receiving funds from the government of India. Then what about Chief Minister? He will be in Lokayukta. What about State Council of Ministers? They will be in Lokayukta. What about the officers who are getting income from the state government? They will be in Lokayukta. Same parallels. What are the jurisdiction? Prime Minister, Union Council of Ministers, all the MPs, Group A, B, C, D employees and officials of bodies receiving government funds. Tell me, officials of bodies receiving government funds. UPSC, CEC, these all who are receiving funds. UGC, whichever the body receiving funds from the government of India will also come under the ambit of Lokpal. Powers. Order preliminary inquiry, direct investigation by CBI, recommend disciplinary action, prosecute corruption cases through special courts. It doesn't have any body. Again, it will give the work to whom? CBI. Tanakantu body ledu. సో అది ఎవరికి ఇస్తుంది, మళ్ళీ ఎవరికి అప్పచెప్తుంది, సిబిఐ. ఆర్డర్ ప్రిలిమినరీ ఎంక్వైరీ, ఇన్వెస్టిగేషన్ బై సిబిఐ, రికమెండ్ డిసిప్లినరీ యాక్షన్, ప్రాసిక్యూట్ కరప్షన్ కేసెస్ త్రూ Lokpal cannot investigate, very important, Lokpal cannot investigate matters related to international relations. Matters related to international relations. For example, Bofors scam was there in 1988, like Rajiv Gandhi time. There was saying that one Bofors gun was 100 crore, but Rajiv Gandhi bought for 330 crore. Means for every Bofors gun, he took how much? 230 crore. That will not come under this. International relations, no. Buying and selling also will not come under this. Defense also, security and defense matters also will not come under it. Certain decisions of cabinet committee also will not come under this. Can't take sumo motu cognizance. Compulsory there should be what? Complaint. Lokpal will act if and only if there is a complaint. Without very important. ఇదే స్టేట్మెంట్ అడుగుతాడు వన్ కన్ఫ్యూజ్ చేయడానికి. Whether there is a requirement of complaint for Lokpal to move on? Yes. Whether it can work sumoto, Lokpal chala peddadi. Yes, it can work sumoto. So it cannot work sumoto. There are some statutory bodies which are in the news I am going to discuss about. National Medical Council. Now, earlier it is called as Medical Council of India. It has been changed to what? National Medical Commission. Frequently, regulation, new exam came which is called as NEXT. Why it is in the news? A new exam was been created by National Medical Commission which is called as NEXT. What is this? You know, there was a problem. People who didn't got MBBS seats, they used to go to Ukraine, Azerbaijan, Russia, Uzbekistan, Turkmenistan and do MBBS. When they come back to India, when Medical Council of India was there, their degree was not accepted. So they studied there for 5 to 6 years and they are coming back, their degrees are not getting accepted. It was a very big problem for the students. While going you are telling we are accepted, while coming with all our degrees you are not accepting. So to give a solution to all these problems, National Medical Commission came up with an exam called as NEXT. Whoever completes MBBS, they should write this exam. Whoever are aspiring for PG, they have to write this exam. Whoever are coming from foreign universities, they have to write this exam. Whoever want to go for medical practitioner, they have to write this exam. So one exam became a universal exam for all the medical practitioners and who want to pursue PG in India. That exam is what? NEXT. That NEXT exam was been created by which body? National Medical Commission, hence it is in the news. Tamil Nadu shouted, Tamil Nadu was telling, West Bengal was telling, why you central government, we will have our own plan, no. Why you are fixing with central government, why you want to keep exam for local, we will keep our own exam. Federal issue came with this NEXT exam. National Medical Commission Act 2019, reform and regulate medical education and medical practitioners, improve transparency, ensure quality and medical education, address corruption allegations. It consists of how many? Chairperson plus 10 ex officio members plus 14 part-time members. Members include representatives from medical education institutions, state government, experts in medical science. Major functions: regulating medical education and institutions, maintaining national medical register, setting standards for medical colleges, regulating medical professionals, promoting medical research and sometimes these questions are been asked, so I took this topic. National Medical Commission will be working through 4 bodies. Under National Medical Commission, 4 bodies are there, inbuilt bodies are there. It will be working with these 4 inbuilt bodies. What are those inbuilt bodies? ఈ క్రింది వాటిలో or from this, which of the following comes under National Medical Commission, which of the following doesn't come under National Medical Commission? What are the 4 bodies? Only 4 bodies are there. What are the 4 bodies? Undergraduate Medical Education Board regulates what? MBBS education. Undergraduate Medical Education Board regulates what? MBBS education. Postgraduate Medical Education Board regulate what? Post graduation. So MEB, MBB is same. Medical Education Board, one is UMBB, other is PG MBB. Third, Medical Assessment and Rating Board. Medical Assessment and Rating Board inspect and assess medical institutions, whether to give permission or whether not to give permission to the medical colleges. Which body? Medical Assessment and Rating. Yes. Ethics and Medical Registration Board maintains medical register and ethics standard. These are the 4 bodies which are working under National Medical Commission. Which of the following body is not working under National Medical Commission? Which of the bodies are working under UMBB, PGMBB? That we can remember. Medical Education Board, Undergraduate Medical Education Board, Post Graduation. Third is what? Medical Assessment and Rating Board, Ethics and Medical Registry Board. These are the 4 boards working under National Medical Commission. Next, common licensing exam for doctors, final MBBS exam, screening test for foreign medical graduates, basis for PG admission. Like GATE exam, basis for PG. Here also what now? Next, one exam, universal exam. Next, Comptroller Auditor General of India. CAG. Which article? CAG 148. Duties and powers of CAG 149. Form of government accounts 150. Submission of audit reports 151. CAG is known as guardian of the public purse. Appointment by the President of India. Holds office for 6 years or until 65 years of age. CAG, Comptroller Auditor General of India. It is also news. Why? Because a new CAG was been appointed. Which CAG we don't want? The procedure is important. Article 148 talks about appointment of CAG. For how many years he will be being? 6 years. Till which age? 65. Most important. He will be removed on the same grounds of Supreme Court judge. CEC will be removed on the same grounds of CEC will be removed on the same grounds of Supreme Court judge. CAG also will be removed on the same grounds of 2 procedures are there. One is called as proved misbehavior, incapacity. Incapacity means unsound mind, proved misbehavior. Which procedure? Procedure for the removal of Supreme Court judge. What is the procedure for removal of Supreme Court judge? What is the procedure for removal of Supreme Court judge? The Lok Sabha will be constituting one committee and that committee will be studying and the report will be submitted to the Lok Sabha. Then the Lok Sabha will go through it and Rajya Sabha will go through it. Then they will have a voting pattern. Which majority? Special majority. When it is passed through both the houses independently, then the person will be deemed to be removed. Duties. They audit what? Union government, state government, government companies, public sector undertakings, bodies substantially financed by government. Types of audit: financial audit, compliance audit, performance audit. See, this is also very important. They will also audit the performance of policy also, whether the policy is good or bad, whether the policy is beneficial or not, whether the policy is helping or not is also been studied by this particular performance audit and compliance audit. So 3 audits are there: financial audit, compliance audit and performance audit. How the appointment will happen? No selection committee, directly appointed by President on his choice. On his choice means whose choice? Central government. So there is no procedure for appointment of CAG. That is the reason there was a decision in Lok Sabha. Chief Election Commissioner, we have a body. Supreme Court of India judges, we have collegium system. Then why we don't have for UPSC members and CAG members? Both are appointed by the whims and fancies of central government and mainly CAG. I will tell you one story. What happened? 2012, 2G spectrum scam. 2G spectrum scam. CAG, at that time he was Vinod Rai, he was very popular, Vinod Rai. What he did? Suddenly one day he came onto the camera and he told that the central government, mainly the Ministry of Communications and Technology, A. Raja, his name is, DMK, because of him the exchequer had lost 1,74,000 crore. 2012, it was a very big blast. 1,74,000 crore we lost, it's a scam, it told. 2014, the UPA government lost its power mainly because of this scam. Actually, it was a mistake of CAG. See, he used the word scam. He used the word corruption. But it was not scam, it was not corruption, it was the loss to the exchequer. అంటే ఏదైతే ఇన్కమ్ ఎక్స్చెకర్ రావాలో ఎక్స్చెకర్ రాకుండా ఆగిపోయిందన్నమాట. ఎందుకు అని అంటే till that time we have a policy called as auction. The electromagnetic waves from this bandwidth to this bandwidth. This is for Aircel, this is for Airtel, this is for Jio. Like that the government will be giving for running their communications, mobile phones, etc. So what happened? In 2012, the government changed its policy and told that no auction, first come first serve. No auction, first come first serve, because we want to penetrate internet. We want to penetrate, everyone should have mobile phone. So we are doing first come first serve. If they go for action, they have to pay some amount, no? That amount will again fall on whom? Customers. When the cost is high, whether we will buy that mobile, we will buy that SIM cards, we will not buy that SIM cards. So what it did, we don't go for auction, we will go for first come, first serve. But here one scam happened, what he did, he called Aircel, DMK, Tamil Nadu, his own friend, Aircel company, Chennai based company. So if early morning 2 o'clock, come and stand in the line. When you come, I will open the door, you first come and sit in the place, first come, first serve. Little bit scam was happened, it was only 5,000 crore, at that level 5,000 is less on. But what the CAG told, the intention was good. So to penetrate mobile phone, to penetrate internet, so that everyone should have internet, so that the mobile prices should be reduced. To be reduced, I should not go for auction. If I go for auction, they have to pay me the amount. If they pay me the amount, again they will put on whom? Consumers. So the government thought we will reduce the amount, so that everyone will have a mobile phone, everyone will have a smartphone, so that they will be using the smartphones and they will be having accessibility to internet. But CAG came and told, exchequer has lost 1,74,000 crore because of a DMK minister. There was for 1 year full ruckus happened and government fallen also. That much important the CAG will play. So this CAG, how he should be appointed? Hence there is no selection committee, he is appointed by whom? President. They submit report to whom? Public Accounts Committee. So CAG will submit to President, President will submit to Lok Sabha, Lok Sabha will submit to Public Accounts Committee. This is the procedure. CAG will submit to President, President will submit to Lok Sabha and Rajya Sabha, and again they will submit to Public Accounts Committee. Who will scrutinizing this report? See, only one thing is there. How to ensure CAG independence? He will be removed on the same procedure as Supreme Court. Salaries and conditions will not be changed once appointment happens. So independent. Salary will be directly charged on Consolidated Fund of India, and he is not allowable or he is not allowed to work after retirement. But whereas, if you see Supreme Court judges or CJIs, they are allowed to work after retirement. For example, I will tell you a classic example you can write in your mains. 2014, lot of judgments, 15, lot of judgments were been favoring central government. Then lot of doubts. For example, Ayodhya judgment. Lot of judgments were been favoring central government. Ranjan Gogoi was a CJI. After his retirement, within 3 months he became Rajya Sabha member. You tell me, he is not from people, he don't have popular support, he is not a politician, he just retired as a CJI, then why he was being made as Rajya Sabha member? There might be some quid pro quo. So what will happen? Sometimes these doubts will come. That is the reason CAG not eligible for government office after retirement. Any sort of government, they are not allowed. Attorney General of India, which article? 76. It is the highest law officer. Below to him who? Solicitor General. Who is above? Attorney General. Appointed by whom? President. Must be qualified to be appointed as a judge of Supreme Court. See, conditions remember, once they asked Attorney General of India, citizen of India, have been a High Court judge for 5 years, advocate in High Court for 10 years, or a distinguished jurist, or to be appointed as a judge of Supreme Court. When he is having all this eligibility, then only he will be appointed as Attorney General. One more thing, his salary is not fixed. This is very important. CAG, CEC, Supreme Court judges, all the salaries are fixed. Attorney General salary is not fixed. Attorney General salary is fixed by the government. Why, sir? Tell me. He is a skilled, I want him. He is very skilled lawyer. For the government, I want skilled lawyer. But government is telling again, give only 2 lakhs rupees. He is expecting 6 lakhs rupees. So the salary is not fixed for Attorney General. The salary will be withdrawn according to the choice of the government of the day. This is a new point. There is no fixed salary determined by the constitution or by the law. The salary will be taken care by whom? Government of the day. Advises Government of India on legal matters, represents unit government in Supreme Court, appears in important constitutional cases, performs legal duties assigned by the President, has right to participate in proceedings of Parliament, speak in both the houses of the Parliament, participates in parliamentary committee, but cannot vote in Parliament. Who is having privileges? Union Home Ministry and Union Ministers and last class, Attorney General. So Attorney General is also having what? Privileges. Union Ministers also having privileges. Attorney General is also having privileges. But Attorney General is not allowed to vote. Does not specify a specific term, hold office during the pleasure of President. A skilled person will be taken. No fixed salary, no fixed tenure, at the discretion of President. Unlike other government employees, Attorney General can engage in private legal practice, advise or appear the government of India, defend accused persons in criminal prosecutions without government permission. He can also talk for other cases. Attorney General, constitutional post, Article 76 is a statutory post, not in constitution. Highest law officer, assist whom? Attorney General. National Commission for SCs. Earlier we have only National Commission for SCs, in which SCs and STs are covered. Then we have a Constitutional Amendment Act and we divided National Commission for SC and National Commission for ST. Yes or no? Originally a combined Constitution Commission for SC and ST, later separated by 89th Constitutional Amendment Act, like National Commission for SC and National Commission for ST. Earlier it was 338, now it is divided into 338 and 338. Which Constitutional Amendment Act? 89th. Chairperson, Vice Chairperson, plus 3 other members, all are appointed by President. How many members are there? 5 members are there. Chairperson, Vice Chairperson plus 3 other members. Total 5 members will be there. These 5 members will be appointed by whom? President on his discretion. How many years? 3 years. Tenure 3 years. Functions, SC problem, and where the SCs are subjected to discrimination, they submit the report to the President. These are all the major functions of National Commission for SC. Summoning persons, requiring production of documents, receiving evidence on affidavit, report submitted to the President of India. President places them before Parliament along with action taken report. President. So, National Commission for SC to President, President to Parliament. On what? Action taken also. On the report. How many members? Chairman plus Vice Chairman plus 3 members. How many years tenure? 3 years. Tribunals Reforms Act. You know that. Article 323A, Article 323B. Tribunals or tribunals. Article 323A talks about administrative tribunals. Article 323B talks about other tribunals. Other tribunals means it can be tax tribunals, it can be human rights violation tribunals, it can be any other tribunal, water tribunals, water dispute tribunals. These all come under which article? 323B. 323A what talks about what? Administrative tribunals only. So what happened recently? Actually 323A, 323B was not there in the original constitution. You know that? It was added by which Constitutional Amendment Act? By 42nd Constitutional Amendment Act, tribunals are added. If not, we don't have tribunals. If not, we don't have tribunals. Tribunals were been added by 42nd Constitutional Amendment Act, by which we added 2 articles, Article 323A and Article 323B. Why? Why? Because we need to have a specialized attention for administrative issues and other issues, whereby a special body, a expert body is required. So that we constituted what? Tribunals. Now a law was been passed in 2021, which is called as Tribunals Reforms Act 2020. Now why we are discussing about it? Supreme Court struck down certain provisions of Tribal Reforms Act, Tribunals Reforms Act 2021, saying that executive is having more power and executive is appointing his members or their members in the tribunals and getting their judgment according to their requirement. There is no specific collegium or no specific selection body for appointments into tribunals. Hence, the independence of tribunals is compromised. On this, in 2025, Supreme Court had struck down few provisions of Tribunals Act 2021, mainly because executive is having more role in the appointments of members in the tribunals. The court held that some provisions gave excessive control of executive in tribunals. The judgment reaffirmed the independence of tribunals and separation of powers. So why recently Supreme Court had struck down Tribunals Reforms Act 2021? Mainly because executive is having higher role in appointments in tribunals, so that the independence of tribunals got compromised. Andukosam news. Why we have tribunals? To reduce the burdens on courts, provide specialized adjudication. 323 and 323B. By which Amendment Act? 42nd. Key provisions: rationalize tribunals, abolish certain tribunals, transfer their functions to high courts or other authorities, regulate appointment and service conditions of tribunal members. Provisions struck down: short tenure of tribunal members 4 members, executive dominance in appointment, lack of adequate safeguards for judicial independence. That is the reason it has been. Separation of powers got violated, independence of tribunals got violated, rule of law is not followed. Why? Because by this legislation you started appointing more number of tribunals, by which you are bypassing High Court. So where the bypass should look into it, you are constituting what? Tribunals. So case should go to where? High Court. But you bypass saying that it's an expert body. So hence you are bypassing the judiciary. Hence you are not following rule of law. On these three conditions, Supreme Court had struck down few provisions of Tribunals Act of 2021. Private Members Bill. What is Private Members Bill? Tell me. A bill which was been placed in the house other than the ministers. Very good. Other than the minister. The person who is tabling the bill can be from the ruling party also. Not only from opposition party. He can be from the ruling party or can be from opposition party also. But not a minister. But not a minister. He is called as, that bill is called as Private Members Bill. Recently, one private member bill was been placed in the Lok Sabha asking for removal of collegium system. The collegium system is so much opaque. The appointments of judges is so much opaque. There is a need for more transparent model. Hence, the private member bill was been in the news. You know the collegium system. What is the collegium system? The senior most judge with 4 senior most judges, CJI with 4 senior most judges. CJI with 4 senior most judges, 5 members will constitute a body, and this collegium will recommend who should become the next CJI or next judges of Supreme Court or next Chief Justice of High Court or next judges of High Court. And the recommendations will be given to the President and it is binding on the President. That body is called as collegium. Against this collegium system, National Judicial Appointment Commission was been constituted. National Judicial Appointment Commission was been constituted but the Supreme Court had struck down saying that there is a role of executive in National Judicial Appointment Commission which will compromise the independence of judiciary. Hence, NJAC was also been declared as unconstitutional. Again, we are following what? The collegium system, the CJI with 4 senior most judges. Here comes the question. Up to now in the history of India, only one time private member bill was been passed and legislated. In the history of India, up to now, only one time government support is not there, no. Who will support one man? Dowry Prohibition Act was been passed by private members bill. And that too, Lok Sabha did not accept it, hence they had a joint session and they passed it. For that we have to appreciate Nehruji, because it was a private member bill, but still he supported the private member bill. The same thing. Appointments. Legislative councils. Legislative councils, see, generally what will happen, there will be a confusion with respect to legislative councils. Wherever you read, there will be very clearly mentioned that legislative councils will be, the legislative councils elections will be done by State Election Commission, true only, but the legislative councils elections will be planned and decided by Central Election Commission, will be executed by State Election Commission. But in the examination hall, the legislative councils elections will be conducted by whom? Means it is Central Election Commission. Central Election Commission. Sir, how it varies, sir? For example, I will tell you. State legislative assembly elections are happening. MLAs elections are happening. The officers will be deputed from Election Commission of India and will be checking. But for legislative council elections, the dates, how the election should happen, the superintendents, the electoral rolls, all will be decided by Election Commission of India. But it will give full independence to State Election Commission to implement it. But it will be happening under the supervision of Central Election Commission. So hence, Legislative Council's elections will be conducted by Election Commission of India, ECI. If anywhere if you see the question, Legislative Council's elections will be happening by which body, which will be conducted by which body means Election Commission of India. Up to now we are having 6 legislative councils. Remember like this, Andhra Pradesh, Telangana, and the border of Telangana is Karnataka. 3. Andhra Pradesh, Telangana, Karnataka. Telangana border is what? Maharashtra. Bihar and Uttar Pradesh. Bihar and Uttar Pradesh. 4 contingency states. Andhra Pradesh, Telangana, Karnataka, Maharashtra. Bihar and Uttar Pradesh. The states, 6 states are having. Which of the following states have legislative councils? Telangana, Andhra Pradesh, Karnataka, Maharashtra, Bihar and Uttar Pradesh. When we have legislative councils and legislative assemblies, it is called as bicameral. It is called as bicameral. If we have only legislative assembly, it is called as unicameral. One is called as upper house, other is called as lower house. Legislative council is called as upper house and the legislative assembly house is called as lower house. Legislative assembly is called as house of the people. Legislative council is called as house of, we cannot call elders, it is not elders. Legislative council is called as house of experts. Legislative councils is called as house of experts. Why? I will tell you. Article 169, it grants Parliament the authority to create or abolish a state council of state legislative council. Why? What is the procedure? If any state want to have a legislative council, in their state legislative assembly, first they have to pass a resolution by special majority. What is special majority? Special majority, 2/3 present, who are present and voting, in that 2/3 plus 1 should be there, and that maximum should be more than the 50% of the house. That should be more than the 50% of the house. 2 conditions. Then only we call it as special majority. So if any state want to have a legislative council, they have to have a special majority resolution in the legislative assembly. Then that resolution will go to the Parliament. In the Parliament, it should be passed by simple majority. There should not be no joint sitting. There should be separate sitting, Lok Sabha separately and Rajya Sabha separately. Then only the legislative council will be established. First, a special majority resolution need to be passed in legislative assembly. Then it need to go to the Parliament, Lok Sabha and Rajya Sabha separately. Then it should be countersigned by President. Then only a legislative council will be formed. As well, legislative assembly is not binding on Parliament. Maximum of 1/3 of total strength. How many members should be there? The maximum number should be 1/3 of the numbers of state legislative assembly, and minimum should be 40. Maximum should be 1/4, 1/3. Minimum should be minimum to minimum 40. Telangana is having how many? 40. Andhra Pradesh is having how many? 55. Now you see experts. 1/3 to 100%, 1/3 is elected from the local bodies by electors consisting of members of municipalities, district boards and such other local authorities in the state. All the local bodies members should be forming electoral college. From that electoral college, 1/3 members will be elected. These people will be called as what? 1/3 local body. Another 1/3 will be elected by legislative assembly members, MLAs. 1/3 local bodies, 1/3 MLAs. 1/12 by teachers, 1/12 by teachers. 1/6 having at least 1/12 is graduates. 1/12 is teachers, 1/12 is graduates. 1/6 is nominated. 5 fields. 1/6 is nominated in 5 fields. What are those? Literature, science, arts, social service, cooperative movements. This is a PYQ. 1/6 of the members of legislative councils will be appointed by 5 bodies. First one is literature, science, arts, social service or cooperative movements. From this we will be choosing our 1/6 of the members. So 1/3 local bodies, 1/3 MLAs, 1/12 graduates, 1/12 teachers, 1/6 exclusively nominated. Nominated who are having experts in science, art, literature, social service or cooperative. These are all the current topics which are within the news since last 1 year. Okay. So what are all the topics we discussed from last class today? Polity, all the polity topics what we discussed. Fast. Privileges, first we discussed about privileges. Next we discussed about 5th schedule, then 6th schedule. Then why 6th schedule? Ladakh. Why 6th schedule? Ladakh. Then next? President's rule. Why we discuss President's rule? Manipur. Next? Setting timelines for governors. If through advice of the Council of Ministers, 1 month. Without the advice of Council of Ministers, 3 months. Next? Next? Speaker impartiality. Speaker impartiality, why? Because a lot of anti-defection laws are there which are not functioning properly. Disqualification of MPs and MLAs. Three sources are there for the disqualification of MPs and MLAs. Constitution itself, Representation of People's Act, anti-defection law. Next. National emergency. 75 years of, 50 years of national emergency. Next. Disqualification of MPs and MLAs. Next. IPU, Inter-Parliamentary Union. Why we discuss, where it happened? Tashbagat. Which summit? 150th. So it is important. Next. Election Commission of India. Election Commission of India, judgment, Anup Barnawal judgment, then Election Commission of India Act 2023. What is the selection committee? And what is SAR? We discussed special intensive revision comes under Article 14 and 326. Next. Anti-defection law we discussed. Next. 129th Constitutional Amendment, simultaneous elections. 130th Constitutional Amendment is simultaneous elections for local bodies also within 100 days. Federal. What are the federal issues? Governor issues, mainly Kerala and India, with 4 issues. First one is what? Borrowing. Second one is what? Revenue deficit. Third one is what? GST compensation. Fourth one is what? Disaster relief funds. Other than governor issues. Other than governor issues. These are called as fiscal federal features. Next. Article 21. Today, Article 21 ambit of it. So, what are the various judgments for each and every? Newly added what? 3. Ministerial hygiene, right to bail and anticipatory bail, right to marry. Other than that, 5 more, right to life and liberty. Next. Article 326. SAR. Special intensive revision. Next. Lokpal, we discussed about Lokpal and Lokayukta. Lokpals were been not constituted properly up to now. Not regularly, they are been not constituted. Unnecessarily Lokpal and Lokayukta we legislated, but there is no Lokpal only. What is the selection committee? What is the jurisdiction? What are the powers? Whether Lokpal have its own body or depends upon CBI? It don't have its own body. It depends upon CBI. Next. National Medical Commission. 4 bodies are there. Undergraduate Medical Education Board, Postgraduate Medical Education Board. Next. Medical Assessment and Rating Board. 4th. Ethics Board. National Medical Commission is abandoned which body and formed National Medical Commission? Medical Council of India. Next. Delimitation Commission we discussed, Census we discussed, NPR we discussed, NCR we discussed, NRC we discussed. Citizenship Amendment Act is nothing. Citizenship Amendment Act of 2019, which talks that mainly who are other than Muslims who are coming from Bangladesh, Pakistan and Afghanistan, other than Muslims who are coming and who stayed in India from last 5 years and above, they will be given what? Indian citizenship. Mainly from 3 countries, Afghanistan, Pakistan and Bangladesh, except Muslims. Next. Attorney General of India, Solicitor General we discussed. Next. CAG we discussed. Then we discussed about National NCSC, National Commission for SC we discussed. Then how many members are there? Vice Chairman plus 3 members. Next. Tribunals. 323, 323B, recently we stuck few, not completely, few provisions, where the executive is having huge power to maintain its independence, the Supreme Court had struck down few provisions. Next. Private Member Bill. Next. Legislative councils. So 6 states are having legislative councils like Andhra Pradesh, Telangana, Karnataka, Maharashtra, Bihar and Uttar Pradesh. And 1/3 is from local bodies, 1/3 from MLAs, 1/12 from teachers, 1/12 from graduates, 1/6 from nominated in 5 fields: science, art, literature, social service or cooperative movements. Clear online? So these are the much topics which are important. Tomorrow we will have regular, more energetic class. Okay, thank you.